Scott Ogle will be right with you.
Hello. Can't hear anything.
All right. Good afternoon, everyone. I'll call case number 200418-C. This is Tony Trigo versus Walmart Stores Texas LLC, DBA Walmart. And can I get announcements from the plaintiff first?
Yes, Scott Ogle for the plaintiff.
And for the defendant?
Sorry about that, I was muted. Meredith Heaton here on behalf of defendant Walmart.
All right. And we have Walmart's motion for leave to designate a responsible third party. So we'll start with Ms. Heaton. Go ahead.
Thank you, Your Honor. Just briefly, we're moving to designate John Doe customer as a responsible third party in this case. This case, plaintiff has brought as a slip and fall premises liability action against Walmart. In plaintiff's lied pleadings, she claims that she slipped and fell in a trail of brown liquid on the floor in the store in April of 2018. Defendant has in discovery produced video surveillance to plaintiff counsel. In that video, you can see a older Hispanic man and his child pass over the area where plaintiff fell within 2 minutes of the fall. Both plaintiff and his child are carrying soda drinks from the McDonald's store that are within the Walmart area. The man actually looks back and down at the floor after he passes over the area, which indicates to Walmart that there was a potential spill on the floor, which could be the cause of the alleged dangerous condition made the basis of Ms. Trigo's pleadings. This case was is relatively new to the court. We served supplemental disclosures and amended answer in October of 2020, identifying this John Doe customer as a potential responsible third party to plaintiff. And we're preparing for today's hearing. I did realize that those exhibits were failed to be attached to our motion. I do have copies that I'm happy to share with the court to evidence that, but I can say that our amended answer is on file from October 20th of 2020, showing that responsible third party allegation. And plaintiff has timely objected, I will say, within the 15 days required by the statute based on a fair notice pleading standard. Plaintiff claims that we have failed to adequately address our John Doe claims here. And I would posit to the court that I believe our motion does meet the fair notice pleading requirements in Texas. 33.004G1 says that the pleading requirements for a responsible third party motion simply follow the Texas rules of civil procedure. Texas Rule of Civil Procedure 47 says that the fair notice pleading requirement only requires a short statement of the cause of action to give fair notice of the claims involved. The Texas Supreme Court in Horizon CMS, a case out of 2000, says that the fair notice pleading standards looks to see if the other party can ascertain from the pleadings basic issues and controversy and relevant testimony. Here we have pled, we have not only provided the video surveillance and discovery, but we've pled that we believe that Mr. John Doe is the source of this spill and or his child, which can be shown on the video, which also shows that other customers have passed over the incident, the area of the incident in question without issue prior to this gentleman and his child passing over it. Unfortunately, you know, we don't know his name or information because it wasn't until litigation was filed that we looked at the video to know one way or the other. And so we would ask the court, number one, to grant our motion for leave. Number two, if the court is inclined to sustain plaintiff's objection, that we be given the opportunity to replead pursuant to subsection G2 of chapter 33.004 of the Texas Civil Practice and Remedies Code, to allow us the opportunity to amend our pleadings to add more detail if the court is so inclined.
Okay. All right, Mr. Ogle?
Yes. Walmart is attempting to point their finger at a potential third party when there's no evidence whatsoever that they spilled anything. They just happened. I've seen the video, and the video shows them passing by this same area where my client had fallen, but there's no indication that they spilled anything. And while opposing counsel refers to Texas Practice and Remedies Code 33.04, you know, their bald allegation that the unknown customer was a source of the brown liquid does not satisfy 33.04. There's no, defendant supplies no facts or evidence that the unknown customer was the source of the brown liquid. The particulars of how this unknown customer manifested as a source of the brown liquid, or how the brown liquid ended up on the floor, or even the defendant became aware that an unknown customer passed the spot. She misidentified the plaintiff that was seen walking with soda. It was the witness rather than the plaintiff that was seen walking past with sodas. And the fact that this person walked past and happened to have paper cups in their basket doesn't necessarily even mean that there were sodas that they had. So the fact that they're trying to spread the blame after they missed the deadline to designate a responsible third party, it's not fair to the plaintiff for them to be able to just point to a random customer that walks by. It does not, the video does not show they spilled anything, and they're not alleging that. They're just asking the court to throw them in because they walked past. And that doesn't meet the standards of 33.04, even if it were a short statement of facts. What statement of facts they have are mere allegations, and there's no evidence that they did anything wrong themselves. That's all I got.
Rebuttal, go ahead.
Just briefly, Your Honor, I would just state that the allegations are short and concise and provide plaintiff with notice of what our allegations are. That's all that's required under the rules. There's no proffer of evidence requirement. Otherwise, all petitions would have to have evidence attached to it. It would be my position that the more appropriate motion would be after discovery is conducted, including party depositions, which have yet to take place. A pretrial motion to strike the designation would be more appropriate should the evidence shake out as plaintiff contends here today.
Mr. Ogle, do you want to respond?
I just want to end with the fact that John Doe is not a responsible third party within the meaning of Civil Practice Remedies Code 33.01. 911 because there is no evidence that the customer with the basket was the source of the spilled liquid. And just because he passes through, once again, does not raise the specter that he was the one that dropped the water. It's just mere allegations on their part with no evidence. And welcome to the Zoom, Judge.
Thank you for that. Ms. Heaton, do you want to add anything?
Nothing further, Your Honor.
Okay. Here's what I want to do. I'm going to take it under advisement. I'm going to double check the code and the cases, and I'll get you guys a ruling this afternoon.
Okay.
Okay. All right. Do you guys need anything else from me today?
Nope.
I don't think so.
Okay. Well then, it was nice meeting you guys. I hope you have a good day, and I'll get you guys a ruling.
You
Okay.
too, Judge. Thank you.
Thank you.
Thank you.